seconds to go. Start. Every case has its own journey towards the truth, and it is the court's role undertake. Truth has to be found on the basis of evidence available before it. There is no room for subjectivity, nor the nature of offense affects its performance. We have a hierarchy of courts in dealing with cases. An appellate court shall not expect the trial court to act in a particular way depending upon the sensitivity of the case. Rather, it should be appreciated if a trial court decides a case on its own merit despite its sensitivity. At times, courts do have their constraints. We find different decisions being made by different courts, namely trial court on the one hand and the appellate courts on the other. If such decisions are made due to institutional constraints, they do not augur well. The district judiciary is expected to be the foundational court and therefore should have the freedom of mind to decide a case on its own merit, or else it might become a stereotyped one, rendering conviction on a moral platform. Indictment and condemnation over a decision rendered on considering all the materials placed before it should be avoided. The appellate court is expected to maintain a degree of caution before making any remark. This court time and again has laid down the law on the scope of inquiry by an appellate court while dealing with an appeal against acquittal under section 378 CRPC. We do not wish to multiply the aforesaid principle except placing reliance on a recent decision of this court in Anwar Ali and another versus State of Himachal Pradesh 2020 10 SCC 166. In the case before this court, the High Court interfered with the order of acquittal passed by the learned trial court on reappreciation of the entire evidence on record. However, the High Court, while reversing the acquittal, did not consider the reasons given by the learned trial court while acquitting the accused. Confirming the judgment of the High Court, this court observed and held in para 10 as under. Once the appeal was rightly entertained against the order of acquittal, the High Court was entitled to reappreciate the entire evidence independently and come to its own conclusion. Ordinarily, the High Court would give due importance to the opinion of the sessions judge if the same were arrived at after proper appreciation of the evidence. This rule will not be applicable in the present case where the sessions judge has made an absolutely wrong assumption of a very material and clinching aspect in the peculiar circumstances of the case. The High Court reversed the order of acquittal passed by the learned trial court and held the accused guilty on reappreciation of the entire evidence on record. However, the High Court did not record its conclusion on the question whether the approach of the trial court in dealing with the evidence was patently illegal or the conclusions arrived at by it were wholly untenable. Stop.